Welcome to CM Guide. Today we're taking a deep dive into a crucial, yet often complex, area of the construction industry in Hong Kong: the legislation around construction contracts, statutory adjudication, and security of payment. It's a topic that might sound quite technical, but its impact on how projects are funded and disputes get resolved is absolutely massive. I mean, it affects everything from grand public works to intricate private developments. We're going to unpack how Hong Kong has approached ensuring fair and timely payments in this vital sector, and crucially, what's changing with new laws coming into force. It's really been a fascinating journey of evolution, hasn't it?
It really has. And what's particularly fascinating here is that Hong Kong's approach to security of payment, or SOP as we often call it, has historically been quite unique, especially when you compare it to other major places like the UK or Australia. For a long time, it genuinely stood apart. So understanding this evolution, this journey, is really key to grasping where we are now and where we're headed.
Okay, let's unpack that unique starting point then. You mentioned Hong Kong took a different path for years. How exactly did security of payment work until recently? And, how did that differ from places that already had statutory frameworks in place?
Well, historically, Hong Kong's SOP system was largely contractual. And that's the key word: contractual. It means that instead of having a mandatory overarching law dictating payment terms for everyone, it was primarily something agreed upon, clause by clause within each individual contract. It really was a significant departure from many other countries that already had these legislative schemes well established. Now, as a sort of transitional mechanism, think of it like a bridge before full SOP legislation could be properly developed and enacted. What's often referred to as the circular came into play. This circular was a pretty comprehensive effort by the government to improve SOP matters, but specifically for government contractors involved in public works projects. So it wasn't a universal law yet, but its provisions were actually incorporated into public works contracts through things called additional conditions of contract, ACC, and special conditions of contract.
Right, so the government kind of led the charge by mandating these terms within their own contracts first, even without a broader law covering everyone. And I understand this started rolling out for certain types of projects from around late 2021, particularly for tenders from the larger government-approved contractors.
That's correct. It kicked in from December 31st, 2021 for tenders invited from what they call Group B contractors, those approved for contracts up to HK $400 million, and the Group C contractors who handle the really big projects exceeding HK $400 million on the government's approved list.
Okay, got it. And just to be clear, when we talk about construction works under this circular, what exactly did that cover?
Yeah, good question. It covered a pretty wide range things like building new structures, obviously, but also reconstruction, maintenance, site clearance, excavation, basically the physical building work. And importantly, it also included related goods and services. That means things like plant and equipment hire, material supply, labor, but also professional services like architectural design, project management, surveying, even engineering testing.
Okay, so it was fairly comprehensive for those specific public works contracts. Building on that, under this contractual system, using the circular, how would a payment dispute actually proceed? What was the mechanism if disagreements arose?
Right. So under this circular system, if we look at the bigger picture, it did establish a clearer pathway for payment claims than maybe existed before in some contracts. Essentially, a contractor submits their payment claim for a prog-rec payment, and the employer then had to provide a timely payment response. That was a key step. Now, if a dispute arose about that claim, maybe the employer disagreed with the amount claimed, or the timing or the quality of work related to the claim, the matter could then proceed to adjudication. It wasn't automatic, but the option was there within the contract terms.
And what did that adjudication look like? You hear the term used a lot.
Well, these adjudication proceedings, and there's commentary on this from cases like Muck-Up Civil Engineering back in '99, which kind of set the tone. They were really designed as a speedy mechanism. The whole idea was settling disputes quickly, but on a provisional interim basis. Think of it like a temporary ruling to keep the cash flowing and the project moving. The adjudicator's decision is, and this is crucial, immediately binding and enforceable. You have to comply, pay up what's decided. But, and this is also important, it's not necessarily the final word. Either party could still pursue a full final determination later through arbitration or litigation in the courts, or maybe just by reaching a new agreement.
So fast, but potentially not final. You mentioned speed. I've heard that timelines were incredibly tight.
Oh, absolutely. The timetable was understood to be very tight. Some commentators even called it unreasonably tight and acknowledged it could potentially lead to injustice because parties might not have adequate time to prepare their case fully. But the courts recognized that Parliament, when creating similar systems elsewhere, was aware of this trade-off. The priority was rapid resolution. And to facilitate that speed, the adjudicator was given a fairly free hand regarding procedure. They weren't strictly bound by court rules of evidence, for instance, and were even permitted to take the initiative in finding out the facts and the relevant law.
That unreasonably tight aspect, though, that sounds like a significant balancing act. Speed versus fairness? How did that play out in practice? It feels like there was still room for issues, even with a circular in place for government jobs.
It certainly put pressure on parties, no doubt, especially the claimant, needing to get their ducks in a row very quickly. It demanded efficiency and organization. And you're right, while the circular was a big step for public works, it still led to significant gap for the wider industry, particularly the private sector. Which brings us to the next major development.
Ah, okay. So this is where the game really changes, right? Hong Kong recently passed an ordinance to overhaul this whole system.
Exactly. This is where it gets really interesting, as you say. The new Construction Industry Security of Payment Ordinance marks a fundamental shift, a truly significant evolution towards a proper statutory scheme.
So it seems Hong Kong decided it needed a more comprehensive, legally mandated approach. What finally pushed this shift to a full statutory framework, and what does this new ordinance actually mean for the industry moving forward?
Well, the ordinance itself was gazetted. That's the formal publication making it law on December 27, 2024, so quite recently. And the main provisions, the parts that really change things, are set to commence operation on August 28th, 2025. That's the key date everyone needs to be aware of. From that commencement date onwards, the ordinance will apply to construction contracts entered into, and its scope is much broader than the old circular. It covers construction contracts procured by the government and specified statutory and public bodies, as you'd expect, but crucially, it now extends into the private sector too. We're talking about private sector construction work contracts with a value of not less than HK $5 million, and also contracts for the supply of those related goods and services we mentioned earlier, again in the private sector, if their value is not less than HK $500,000. So it captures a much wider range of projects now.
$5 million for works, $500,000 for goods and services in the private sector. Okay, that definitely broadens the reach significantly. And what does the actual payment framework look like under this new law? Is it similar to the circular's process?
It builds on some of those principles, but makes them mandatory and sets clearer deadlines. Under this new mandatory framework, a claiming party can serve a payment claim, typically monthly unless the contract specifies otherwise. The paying party then must respond within 30 days or a shorter period if that's what they've agreed in the contract. They can't just ignore it. Then, the amount they admit is due in that response must be paid within 60 days of the original payment claim being served again, or shorter if agreed. And the ordinance clearly defines when a payment dispute arises. It happens if the paying party fails to respond within that 30-day window, or if the amount they admit is less than what was claimed, or, importantly, if they admit an amount but then fail to pay it in full by the 60-day deadline.
Okay, so clearer rules, mandatory responses, firm deadlines. That sounds much more robust. So if one of those dispute triggers occurs under the new ordinance, how does the statutory adjudication process work? Is it different from the contractual one under the circular?
Yes, this is where the statutory part really kicks in and makes a difference. If a payment dispute arises, as defined by the ordinance, the claiming party now has a clear statutory right to initiate adjudication proceedings. They can do this within 28 days of the dispute arising. Once an adjudicator is appointed, and there will be mechanisms for that appointment, they have a set time frame. They need to make a determination on the dispute within 55 working days after their appointment, though the parties can agree to give the adjudicator a longer period if the case is complex, for example. But here's the really critical part. The adjudicator's determination under the ordinance will be enforceable by the court.
Enforceable by the court. So what does that mean practically? No more arguments after the decision.
It means the decision carries real weight. It's not just a strong suggestion like the old system might have felt sometimes. If the adjudicator decides an amount is payable and the paying party still refuses to pay, the claimant can take that determination straight to court and enforce it almost like any other judgment debt. It drastically simplifies and speeds up the process of actually getting the cash that the adjudicator says is due. It bypasses the need for potentially lengthy and costly secondary legal proceedings just to enforce the adjudicator's decision.
Wow, okay. That sounds like it gives contractors significantly more leverage, real teeth, as they say.
It certainly does. There is one important exception to note currently, though. For contracts procured by the private sector, this statutory adjudication procedure doesn't yet apply to disputes that are purely about time-related payments, like extension of time costs. That specific aspect is deferred until a later date, which the government will announce. But for quantum, for the actual value of work done, it applies.
Okay, that's a key nuance for the private sector for now. But even with that exception, the court enforceability is a huge change. What if, despite an admitted amount in the response or an adjudicated amount, an employer still drags their feet and doesn't pay? Does the ordinance offer anything beyond going to court?
Absolutely. And this is another powerful new tool baked into the legislation. It's the right to suspend or reduce the rate of progress. This right kicks in under two main conditions. Firstly, if the claiming party served their claim properly, the paying party responded admitting a certain amount was due, but then failed to pay that admitted amount in full by the payment deadline. Or secondly, if the paying party has failed to pay an amount determined by an adjudicator.
So if the money isn't paid when it should be.
Exactly. In those situations, the claiming party can issue a formal notice. It's a notice of their intention to delay the works, which means either suspending work completely or reducing the rate of progress. They have to give at least 5 working days notice before they plan to start the suspension or slowdown. Now, if the outstanding admitted or adjudicated amount is still not paid in full before that intended start date of the delay, the claiming party can then go ahead and delay the work or delay the supply of related goods and services without it constituting a breach of contract on their part.
Without breaching the contract, that's massive.
It is. It fundamentally shifts the risk. Previously, a contractor might feel immense pressure to keep working even without payment, fearing they'd be liable for delays if they stopped. Now, the law explicitly protects their right to pause work if they're not being paid according to the rules. It turns project progress itself into leverage for payment. And not only are they protected from breach claims, but they are also entitled to claim an extension of time for the period of the suspension or slowdown, plus any reasonable loss and expenses they incur because of it.
So it directly links non-payment to consequences for the project timeline and cost, putting pressure back on the paying party. That seems like a very practical enforcement mechanism.
Precisely. It's designed to encourage prompt payment by making the consequences of non-payment much more immediate and tangible.
So looking at the big picture then, what does all this really mean for everyone involved in the industry? Contractors, employers, consultants, as they look ahead to August 2025 and beyond. How should they be preparing?
Well, overall, it signals a pretty significant cultural and operational shift. It's not just about new clauses and contracts. It's about changing how payments and disputes are managed day to day on projects in Hong Kong. Stakeholders really need to start reviewing things now. Look at your existing project payment arrangements, even for future projects. Dust off your standard contract documentation it will need updating, and crucially, align the practices of all the relevant people involved in your projects: project managers, contract administrators, finance teams. Everyone needs to understand these new timelines and obligations. Ignorance won't be an excuse. We also fully expect the government will publish further detailed guidelines and codes of practice on how the ordinance will be implemented, especially around the nuts and bolts of the statutory adjudication regime. So keep an eye out for those in the coming months. They'll provide much needed clarity.
It sounds like a period of adjustment, but ultimately aimed at a healthier payment culture. So today, we've really dug into the evolving world of construction payment legislation here in Hong Kong. We've traced it from those unique contractual origins with the circular right through to this comprehensive new statutory framework under the ordinance. We've seen how these changes are designed to foster more timely payments and much more efficient dispute resolution, things that are absolutely vital for any thriving construction industry. As we wrap up this deep dive, maybe here's something to consider. How will this newly legislated framework influence not just the legal side of construction, but perhaps the deeper culture of project delivery? Things like trust, collaboration, risk allocation. How might those shift within Hong Kong's very dynamic building sector in the coming years? That's a question I think will be fascinating to watch unfold.
Absolutely. And if we connect this to the bigger picture, it really underlines Hong Kong's commitment, I believe, to strengthening the stability and fairness of its construction industry. It's about making the foundations of the industry itself stronger for the future.
Before you go, please don't forget to share, like, or subscribe. Also have a look at other episodes and visit CM Guide website for better insights on this topic.